Good afternoon, everyone. Welcome to another Employment Rights Question and Answers live session. My name is Samara Belitzky. I'm a lawyer at Samfiru Tumarkin in Ottawa. I assist clients throughout all of Ontario, but I am located in Ottawa. And I will be here for the next 30 minutes or so to answer all of your questions related to workplace issues, employment law, whatever the case may be. If you have questions about severance, layoffs, vaccination mandates, anything to do with workplace health and safety, whatever the case may be, I'm here to answer your questions. Send in your questions, and I will be here to answer them for the next half an hour or so. So don't be shy if there's something that you've been wondering about, or maybe a friend or a family member has been wondering about, please send your question in. As usual, there are a couple things that I am prepared to talk about that we've been getting a lot of questions about this last couple of weeks that will be helpful to most people who are watching. But if I don't get to that, that's okay, because we're here to answer your questions. So I'd much rather be doing that rather than rambling on for the next half an hour. So send in your questions, and I see there's a couple coming in right now. We'll get to your questions and assist you however we can. For the time being, while I'm waiting for some of these questions to come in, I'll talk about a couple of things, like I said before, that have been coming up very recently. So the first thing that I was going to talk about today that seems to be pretty prominent these days is severance packages being offered with working notice. And I've had questions from a few people this week about what that means and whether they can refuse working notice or how their rights are affected by that. So I wanted to clarify that because it seems to be a very common issue coming up. So when it comes to severance packages and terminations, when we're dealing with severance, it's important to know that the default is, in most cases, working notice. So a lot of times somebody will be let go and they'll be offered a severance package equal to X amount of weeks or months. But an employer can provide working notice, and sometimes that is what's provided. Most of the time, it makes more sense in the circumstances to provide severance pay and pay in lieu of notice. But if working notice is provided, that is something that would count as part of a severance package, and it would be a situation where the employee would be working during a specific period. And it can be a situation where oftentimes we see a combination where somebody may be provided with, a month of working notice and then severance pay in addition to that. But whatever the case may be, it's really important to make sure that you get advice from an employment lawyer before you agree to anything. So just like a regular severance package, if any part of your severance package is working notice, or maybe the entire offer is working notice, you need to make sure that that gets reviewed by an employment lawyer. You can always use our free severance calculator in order to check what it might be, see how it compares against what an estimate of your severance could be, and be able to move forward from there. But there is no replacement from getting advice from an expert in employment law and making sure that whatever it is you've been offered, whether it's working notice, severance, a combination of the two, it's the right amount. Oftentimes it's not, and we're able to assist you in getting what you're owed. I'll get to the questions here because I have a bunch coming in. So I have a question from JC2004X on YouTube, who's asking, in the event of getting stuck and or unjustly detained due to a protest, does an employer have the right to discipline you? Given the protest, it wouldn't surprise me if this may happen. So what's being referred to here, which most people are probably aware of, is a lot of the trucker protests and the convoy that's been traveling across Canada, and it's been in the news a lot this week, and actually supposed to be in Ottawa today and throughout the weekend. So especially here in Ottawa, we've been hearing a lot about this. And if in fact that's what you're talking about, if you are part of a protest that has nothing to do with your employment, and you are detained, your question says unjustly, but whether it's justly or unjustly, that should not have any sort of impact on your employment as long as it doesn't actually impact it. So what I mean by that is, if let's say you're detained and you're unable to go to work because you're under arrest, for example, and you're being held and you miss work because of it, that could be a situation where the employer can discipline you for missing work. Now, the discipline would be related to missing work. It wouldn't be related to the reason for missing work, and it would always depend on the context and the circumstances that surround that. But generally speaking, whether it be because you're detained or whatever the case may be, if there isn't a valid reason for having to miss work, oftentimes there can be discipline imposed because of that, but it will always depend on the surrounding circumstances. And to that point, I actually had somebody consult me recently who was arrested for a DUI and had their car impounded, and they weren't able to attend at work. So they decided, not to take the bus, or they couldn't take the bus. They couldn't get a ride. They weren't able to go to work because they had been arrested for a DUI and their car had been impounded for about 7 to 10 days. So that's an example of a situation where there can be discipline imposed if somebody isn't able to attend at work when they're supposed to be attending at work. Again, I can't stress this enough. Every situation is different. So if you're ever in a situation like that, you definitely want to be getting advice from an employment lawyer and make sure that you know what your options are and what your rights are and what your employer's rights are in relation to the issue that has come up, because every situation is different. And when we're dealing with issues like this, arrest, detainment, very often the exact circumstances will dictate what it is an employer can or can't do. And to add to that, I see you just added another question. Yes, so if, let's say, the roads are closed because of a protest and somebody can't get to work, notwithstanding their best efforts, it's impossible for you to get to work due to circumstances that are completely outside your control. No, there can't be discipline applied in a situation like that. An employer should not be disciplining an employee for missing work in a situation like that, because that's completely out of an employee's control. So what we're talking about when I say there could be discipline is when there is something that is within, at least to a certain extent, the employee's control. There's something that the employee has done that has led to the situation where they can't get to work. If the roads are closed, whether it be due to a protest or bad weather, which is happening a lot lately, in the last few weeks with the winter, those are circumstances that are outside of an employee's control. There should not be any discipline implemented in situations like that. I have a question here from Optimus Prime on YouTube, who says, I have heard many people say that mandates aren't laws. Can you explain what a mandate is and how it relates to a law? So mandate can mean a few different things. So generally speaking, these days, when we speak about COVID-19 mandates and vaccination policies, when we hear mandate, we think about the policies that employers are implementing. Many employers are implementing mandatory vaccine policies. And so I've heard from a lot of people about that in the last few months. And oftentimes we use the word mandate when an employer essentially is mandating that an employee be vaccinated in order to continue working. So when we're talking about that context, an employer that's implemented a mandatory vaccination policy or mandate, that isn't a law. That's a workplace policy. Where it is a law is where the government has actually come in and changed the law and enacted legislation, like a regulation or another type of legislation that actually legally mandates certain things to occur. And an example of that would be Directive 6 from the provincial government in Ontario. And there are similar directives throughout Canada, but specifically in Ontario, I'll give you a few examples. The provincial government has made it mandatory, and they have made it the law, for employees of long-term care homes to be fully vaccinated. And they've enacted legislation and actual law that explains that and that outlines that has come into force. Similarly, Directive 6 in Ontario mandates either vaccination or rapid testing in the healthcare sector. So those are examples of mandates that are actually laws, that are actually legal mandates that have been implemented throughout the pandemic with respect to COVID-19 vaccination. But again, when we're talking about employment policies, workplace policies, those are not laws. Just because an employer implements a policy does not make it the law. If the employer is acting on the legal mandate, so if it's a long-term care home or a healthcare sector employer, those employers have to implement policies by law because of the laws that the government has put into place to mandate vaccination or, and or testing in the workplace. Apart from the sectors or industries that do have a mandate in place by the government, where there is actually a law that's been put in place, aside from those situations, it is not a law. It's a situation where an employer has implemented a workplace policy and they are wanting the employees to comply with that policy. Now, in terms of those types of policies, we have been getting lots of questions about these types of policies, again, often referred to as mandates because they're considered to be mandatory policies within the workplace, but they're not laws. Lots of questions about this. And, to be clear, if you're impacted by this and you're watching today, unless the government has mandated that you have to be vaccinated in order to continue working. And I just gave some examples of that in Ontario. We have long-term care homes, we have the hospitals and healthcare sector where there's the option that the government has provided of rapid testing or vaccination. And at the federal level, the federal government has changed the law as well with respect to all core public administration employees for the federal government, which is the vast majority of federal government employees would have to be vaccinated in order to continue working. So those are the main categories that would apply to anybody in Ontario, at least. Unless you're in a situation where there is actually a legal mandate, then your employer should be providing you with severance if you're put on an unpaid leave or a suspension, or you're terminated. So if you've been terminated for cause, you should get in touch with us because we can assist you in pursuing severance. If you've been put on an unpaid leave or an unpaid suspension because of a refusal to comply with a mandatory vaccination policy, you don't have to accept that. You can actually treat that unpaid leave or that suspension as a termination of your employment and pursue severance. So you are in a situation, if you're on an unpaid leave, suspension, or you've been terminated, you do have options. And we've been assisting people with these issues throughout the last few months. And so if you do find yourself in a situation like that, you should absolutely be contacting an employment lawyer. We would be more than happy to assist you because you absolutely have a legal argument here to pursue severance. And we have been doing this on behalf of many, many people over the last few months. So you can always get an idea of what you're owed. You can go to pocketemploymentlawyer.ca. That does give you an estimate. As I said before, it gives you a good estimate. You can use our Pocket Employment Lawyer, our severance calculator, but there is no substitute for getting legal advice from an employment lawyer. And that's what you should be doing in every situation involving, your employment and the workplace. Just scrolling through, we have a lot of comments today, so I'm just trying to get through to the actual questions. So I have a question here from the Dreamer on YouTube who asks, can you explain overtime averaging agreements, how they work, and what it means for employees that have one? So it's a great question that we often deal with this issue, but it's not done properly through an overtime agreement. So generally speaking, under the Employment Standards Act, which is the law that contains the minimum standards, rights and obligations of employees and employers in Ontario. And for the other provinces, there is similar legislation that contains very similar rights and obligations. There is a standard for overtime. So what that means is in Ontario, anything over 44 hours a week is considered overtime. And that means the employer would have to pay an employee at time and a half for any work over 44 hours per week. And that in and of itself is, by default, it's supposed to be pay at time and a half. There is an exception to that where an employer can actually pay it as, have it banked rather than it be paid. So rather than paying it out at time and a half, it can actually be banked, but it has to be banked at time and a half as well. And in order for that to occur, the employee has to be in agreement. So if you're an employee and your employer is proposing that to you, they want you to bank it instead of paying it out to you every so often, that also needs to be in writing. It could be in an employment contract, it could be its own agreement, but you do need to have an employee's agreement on that issue in terms of banking versus paying out. So I just wanted to mention that as a connected issue. Now, when it comes to the overtime averaging agreements, sometimes there are situations, workplaces, jobs, where there is overtime, but you may only have it in 1 week where you're working, let's say 50 hours, and then the next week you may only be working 25 hours. So between the 2 weeks, if you average it out, there may not be much overtime or any overtime at all because of the inconsistent hours in certain jobs. And so in situations like that, where an employer may not want to provide overtime for 1 week when the next week there's going to be less hours available, an employer can propose an overtime averaging agreement, provide that agreement in writing to the employee, and then you would be in a situation where, as an employee, if you agree to that, your overtime would not be calculated per week. It would be calculated over a longer period, and you would only have to be paid overtime if you're considered, let's say, over a 2-week period. If you've worked more than 88 hours, the 44 per week times 2, if you've worked over 88 hours in the 2-week period, then you get overtime pay. So that's just a quick example of how that might work. But again, it needs to be in writing and the employee has to agree to it because it's a deviation from the regular way things work. And the employer also has to provide notice to the Ministry of Labor. So if you're, or the Employment Standards Officer, I should say. So if you're an employer and you're in a situation where you do want to introduce overtime averaging agreements, first of all, you want to make sure it's drafted by a lawyer, because if there is anything in the agreement that is potentially unlawful, even if it's unintentional and you meant to do it properly, you meant to do it lawfully, if it's not done properly, it will not be enforceable. So you want to make sure that an employment lawyer is drafting that for you. And you want to make sure that you're notifying the proper authorities, because the Employment Standards Officer and the Ministry of Labor have to be aware that your workplace has deviated from the norm, that you have everything in writing, you've done your due diligence, everything is done properly, and they have notice and a copy of exactly what is happening. So that's how that works. Whether you're an employee or an employer, it's very important to know how these types of agreements work. It doesn't affect every workplace or every job, but there are certain jobs, for example, in the construction industry, I've seen this before. I've also seen it even in the dental industry with dental offices. So certain jobs do have that as an option, but as an employer, there are certain steps that need to be followed, and you need to have an employee's consent. I have a question here from Sudim on YouTube who says, can I refuse rapid antigen testing? I feel it's against my rights. The answer is it depends. there is no black and white when it comes to rapid testing. It will depend on the workplace. It will depend on your job. It will depend on your proximity to other people. All of those things will be part of the legal analysis, looking at the context and the circumstances surrounding your particular job and workplace in order to assess whether it would be reasonable for an employer to request testing or not. The other thing that will be assessed is the frequency. So it may be reasonable in the circumstances for an employer to want to test 1 to 2 times a week or once a week, something of that nature. But where it may become unreasonable is if an employer wants you tested every single day. Again, there is no hard and fast rules when it comes to this type of issue, the testing specifically. It is all dependent on your particular circumstances. So if you're not sure about it, it's important to get in touch with us and get advice from an employment lawyer. You can always visit our website at employmentlawyer.ca. We have lots of information about vaccine mandates and rapid testing on our website, but you can also use our website to get in touch with us, contact any of our lawyers. You can also email us at help@employmentlawyer.ca, and somebody will get back to you because, like I said, every situation is different. So what you don't want to have happen is you refuse rapid testing in a situation where it may be reasonable, and then you're in a situation where you're put on an unpaid leave or you're terminated, and you may not be able to get severance. It's not likely that that would be the case, but there are very limited exceptions. And so before you make a decision, before you refuse something, it's important to make sure that you have all of the information so you can make an informed decision on what you want to do. And that will be, especially when it comes to rapid testing, it will be very different from one situation to another. The other thing that I'll add about rapid testing that we've been seeing a lot of is the rapid testing being offered as an alternative to vaccination, but at the employee's expense. And the employer is the one that should be paying for the tests. If it's become a temporary condition of your employment that you need to get tested once a week or whatever the case may be, you may have no issue whatsoever with getting tested, but you may take issue with the fact that the employer wants you to pay for it, and rightfully so. If it's something that the employer requires and that they're requesting happens, they should be the ones paying for it. And we know at this point in the pandemic, we know that employers are able to order these tests. There are programs that are available for employers to be able to procure the tests, provide them to their employees. I've heard from lots of people over the last few weeks that have had their employers do that, get the tests for them, give it to their employees. That's what should be happening. So if you're in a situation where you're fine with the testing requirements that have been in place, but you don't want to pay for it, get in touch with us. We can assist you in navigating the situation. I've recently just assisted a client who had that exact issue where they were fine with the testing, it was reasonable, but they didn't want to be paying for it. And I assisted him in dealing with the employer on that issue, and the employer ended up paying for it and agreeing to, either pay for it themselves if they could get the test directly, or reimburse the employee for any expenses that they incurred. So, there is a possibility that things can be improved and the employers can change their minds on these issues once you get a lawyer involved. But you do have to know your rights first to be able to do that. So by default, the employer should be paying for it. I have a bunch more questions coming in. I will get to as many as I can here. I have a question from, I think, Tibbs on YouTube. The new right to disconnect law in Ontario says that it is for companies with more than 25 employees. Is that employees in Ontario or nationally? So that right to disconnect legislation is an Ontario legislation. So it only applies within Ontario. And so it's with respect to companies with 25 employees or more in Ontario. So it wouldn't necessarily apply nationally. It depends on the circumstances, especially right now with so many people working remotely. If you are working for an Ontario company, You really shouldn't be working remotely from another province. It should be within Ontario for many different issues, but one being workplace safety, WSIB, workers' compensation. That issue is a big one for why, most companies will not allow workers to work outside the province, because then you lose coverage. If there were to be an accident or a workplace injury, there could be an issue with coverage. And if you get injured, you might not be covered under workers' compensation, again, depending on the circumstances. But to kind of get back to your question here, it's with respect to employees in Ontario. I have a question from Bill Sullivan on YouTube, who says, I was dismissed without cause for not reporting harassment, not allowed to return to work site. I am treating this in court as a constructive dismissal. Okay, Bill, do you have a question? If you do have a question about this, please send it in. I'm more than happy to answer your question. If you're already in court, you may already have a lawyer. And if you're in small claims court, you may be representing yourself. But otherwise, happy to answer any questions you might have about that. And definitely sorry to hear that, you were let go, for voicing your concern. Yeah, I mean, if you are not allowed to return to work and they've barred you from the workplace, that is a termination. And, you certainly could be looking at that as a constructive dismissal or even an outright dismissal, depending on the situation, and pursue your severance. You would also, in a situation like that, have an additional argument of reprisal, claim for reprisal. So if you report any sort of workplace misconduct, whether it be a health and safety issue, whether it affects you individually or not, if it's a health and safety issue, if it's, that includes physical hazards, harassment, bullying, toxic workplace, if you put forward a complaint about anything that may seem unlawful in your workplace, if you are let go because of it, and it's hard to prove, but oftentimes the circumstances do show. If you make this complaint and you're let go the next day, it's pretty obvious that that's why you were let go, barring some other, exceptional situation. Then you would have a claim against your employer for reprisal. And reprisal means that you are being treated in a negative way for enforcing your rights in the workplace. And it can be different. It doesn't necessarily have to be a termination. It can be any sort of negative treatment. So maybe you're demoted. Maybe your hours are reduced. Maybe you're given, a worse shift than what you had before. Or maybe somebody is just treating you poorly in the workplace. Your manager is treating you poorly after you've reported it. Whatever the case may be, if this is something that's occurring and you've reported some sort of unlawful or potentially unlawful activity in the workplace, that could be deemed as reprisal, and that's against the law. And so in terms of any sort of reprisal complaints, something that you could absolutely consult a lawyer with, and I often do assist my clients with that, in addition to severance, if for example they're terminated after a report. It's also something that you can file a complaint with the Ministry of Labor for. So if you feel like you've been subject to reprisal, you can absolutely file a complaint with the Ministry of Labor. You don't need a lawyer to do it. It's free. And then the Ministry of Labor will investigate and come to a determination of whether your employer committed reprisal against you. I have a lot more questions here that I haven't been able to get to. I will answer one more question. If we didn't get to your question today, please, you can contact us. You can contact me directly by going to our website, employmentlawyer.ca. You can find all my contact information there. You can also email us at help@employmentlawyer.ca. And we also have question and answer sessions live throughout the week. And our next one is actually on Monday. So if you didn't get your question answered today, you can definitely tune in on Monday with one of my colleagues, and they should get to your question then. Like I said, I'll answer one more question, and then we'll finish off for today. So I have a question from YouTube. Can employers provide you with a severance out of goodwill, even though it was with cause? The short answer is yes. So if an employer thinks that they have cause to terminate, oftentimes it's a gray area for employers, and they may not think that they absolutely have cause. There may be some misconduct, because in order for an employer to have cause, there really needs to be egregious misconduct and willful misconduct that was engaged in on behalf of the employee. And short of that, it's without cause and severance is owed. So there are only two categories of terminations. There's cause, and if there wasn't willful misconduct, automatically it's without cause and you're owed severance. So if an employer thinks that they might have cause, but they're not sure, the odds are they don't have cause. And in a situation like that, they may even say in a termination letter, notwithstanding the fact that we had cause, we're still offering you a severance package. That's a tactic to get you to accept what they're offering you right off the bat. So if ever you see that in a termination letter, that's a red flag that should tell you you're probably not being offered as much as you should, because like I said before, either an employer has cause or they don't. If they're offering you something, they likely know they don't have cause. Sometimes, in certain circumstances, an employer may very well have cause and still offer a severance package, a very minimal one, because they want you to sign a release that abandons all legal recourse against them, so that they know that this is an issue that's going to be resolved. They don't have to be concerned or worried about any claims or complaints that you may file against them in the future. And so for some employers, even though there might be cause, it makes sense for them to offer a nominal amount of severance for the peace of mind of knowing no further issues will come from this termination. And so it does happen, more specifically to answer your question, it does happen sometimes where an employer may have cause and they still offer severance. They certainly can. An employer can do that, and they oftentimes do. But more often than not, what we see is a situation when an employer says they have cause, but they really don't. And they try to get away with paying you less, even though you're owed much more. Okay, so it's really important to make sure you're getting legal advice from an employment lawyer in that type of situation to make sure that you're getting everything that you should. All right, so that was the last question for today. Again, if we didn't get to your question, I'm sorry, but you can absolutely contact us in the ways I've mentioned, and join us again on Monday when we have another question and answer session. So thank you very much, everybody, for joining us today, and have a wonderful weekend.